Nancy, you ready?
Yes, sir.
Yep, all
Thank
right.
you.
We're back on the record. This time we're taking up the case of People of the State of Michigan versus Fred Corey Newman III. This is case number 25-14141 FH. Appearances, please.
Jake Burns on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Newman.
All right, thank you. Mr. Newman joins us today from a Michigan Department of Corrections facility via Zoom. Mr. Newman, are you able to see and hear the court today, sir?
I am, Your Honor.
Thank you. Mr. Newman, we had talked about this before, but I want to re-advise you. You have the right to be physically present in the courtroom when a sentence is issued. You, however, do have the right to waive that and allow us to conduct it today via Zoom. Do you still waive that right to be here in person?
Yes, Your Honor.
Thank you. Mr. Harrison, any objection?
None whatsoever.
The court finds that the appropriate court rule applies and allows the court to conduct sentencing. Also here this morning is Mr. Kevin Stapleton. He is the agent from the Michigan Department of Corrections who has prepared the pre-sentence investigation report in today's case. Let me take a quick look, see if I had any changes or corrections. All right, I did not note any. Mr. Carnes, did you receive a copy of the PSI? And if so, do you have any amendments, corrections, or objections to make to the content or scoring in the report?
Yes, Your Honor. I have received and reviewed that report. I would like to challenge the scoring of OB-19. I think it should be scored at 10 points. And in support of that, I would like to add a paragraph and then an affidavit to the description of the offense. The affidavit reads, Fred admitted to Agent Van Ackmel he was watching and screenshotting images when MDOC agents arrived at his house. He stated he cleared his browsing history and deleted screenshots due to the agent's presence at his home. I think that is interference with law enforcement supporting 10 points.
Mr. Harrison, your response, of course, we're talking again about offense variable 19, which is for interference with the administration of justice or a penal institution or threaten the security thereof. And Mr. Carnes is apparently requesting 10 points for alleging the defendant otherwise interfered with or attempted to interfere with the administration of justice. Your response, sir?
It's sort of like a twofold response. One, I don't think the browser history would have been particularly useful to the agents in this case, given the fact that there were already a number of questionable images on the computer itself.
Tell me a little bit more about that. What images were still on? Were they found on the computer? Yeah, what happened here? So the images were still found, but the browser history, which was shown at least without having the computer go to the computer crimes unit. The images were still there though.
Well, I mean,
yeah,
probably, but there might have been additional images with him saying he was deleting screenshots. Ultimately, we don't know.
yeah.
Right.
Yeah, it's actually a little more interesting than one would initially think. Did he interfere with it? Or did he attempt to interfere with deleting the browser history?
Well, there's
What?
case law that says he doesn't have to actually interfere with it. Just his intent to do so is
I know, but so here's the point. The images that were found, I would like to know, were they only found because of the computer crime unit doing a forensic dump of the phone or device, or were they found even in a nonchalant or unprofessional, not unprofessional, non-expert.
No, Your Honor, they were only found after the device went to the CCU.
All right, that to me, I think is the key issue. Because if there was a deletion of the browser history, then that would be an attempt to, if, for instance, the probation officer or law enforcement officer had walked into the residence, turned on the laptop and had discovered the images there saved, then I would say, no, there wouldn't be a scoring. At least I would favor a conservative review. Right. The court will grant the request to change offense variable 19 from 0 to 10 points. Thus far, that gives us a total OV of 10 points. And on a class F felony, I don't know if that's going to impact it much or not.
It
does a little bit, Your Honor, not too much, but it changes 12 to 24.
All right, thank you. All right, it's probably not going to have any real impact on my sentence anyways today. Because like I said, it changes the guidelines all by a month or two. So I'm not going to consider that excessively. All right, anything else, Mr. Carnes, the challenge?
No, Your Honor, I do wonder if it's worth adding those sentences to the description of the offense narrative.
Yeah.
So that
That's a good idea. Mr. Stapleton, you can just add that little language to the description.
Yes.
All right,
Again,
thank you. Anything else, Mr. Carnes?
No, Your Honor, thank you.
Mr. Harrison, any challenges, objections, corrections that you wish to request on behalf of the defendant?
Nothing of that nature, Your Honor.
All right, allocution then, Mr. Harrison?
Well, here's the thing that kind of seems to be the theme here. And it's spelled out pretty succinctly in the report. Mr. Newman didn't learn his lesson after his first arrest. It's easy to say, it's an easy conclusion to jump to, given the fact that there were CSAM images found on an electronic device in his possession. However, I don't know if this court has, I believe you have seen the images. We had ample discussion, fruitful debate about whether those images qualified under the statute. And I don't think I'm going out too far on a limb to say it was a rather close call. So I would temper that a little bit. Was it a wise thing for him to do, given his background in history? Of course not. And that's really what it comes down to, is this was a stupid effort on Mr. Newman's part to circumvent the statute. He had been given bad advice that if the images were not of a real person, they couldn't qualify as CSAM under the statute. That we know now that that simply isn't the case. The statute could be better worded and likely will be in the future, but there is enough establishment of enough case law that we were able to determine very early on that that mere statement would not be a defensive posture in this case. That notwithstanding, as everybody can tell, as we look on the screen, he is currently incarcerated. And we're a little bit uncertain as to the overall impact this will have on his current prison term, et cetera, et cetera. It's rather complicated because there's also a parole violation with a mandatory consecutive designation as well. I think I get what the report is trying to say. I get it's worded such as, I can't believe this guy did this. This was really dumb. Sentence him at the lower end of the guidelines because of the facts and surrounding circumstances. I agree with that conclusion, and I would encourage the court to do so. As an aside and an additional request, this is something that has never been brought to my attention before, but between people in this room. We would ask that the collection of fines and costs be suspended during the period in which he is incarcerated. That sounds like a minor thing, but he only gets $30 a month, and a tube of toothpaste costs $6 in the prison system. So it is a day-to-day thing. Yes, there ought to be a sanction. We're not arguing that. Yes, it's entirely proper for a court to impose court costs and fees, so we're not making that argument either. We're simply saying, let's recognize the reality of his situation. It makes very little sense to deprive him of the basic necessities that he needs to have while he is incarcerated. Thank you.
Thank you. Mr. Carnes, on behalf of the people?
Yes, Your Honor, thank you. I would just take small issue with Mr. Harrison. I don't think this was a close call. I think there was a change in law some years ago, and I can't remember the exact time, because I do recall an older case that stated, well, just a representation of a child isn't enough. And then obviously the legislature responded to that case. My second point is that I did take into account the nature of this. There's no actual children victims in this. That was the reason I offered to get rid of the second subsequent, which is a big favor to the defendant because that is a 5-year minimum. I say all that because I do think a sentence in the middle or even towards the upper end of the guidelines is appropriate. I'd ask the court to sentence the defendant to 20 months prison on this. Thank you.
All right, Mr. Newman, you have the right to make a statement if you choose to do so before I issue a sentence. Is there anything you wish to say today, sir?
There is, Your Honor. When it comes to the parole violation summary in regards to my browser history, that was taken into factor for my current parole violation. I'm currently serving on a violation that includes that part of my summary. And this sentence won't actually start until April 23rd, which means I would have already been incarcerated for a total of a year. I would like to ask the court to please consider that, because my parents are both pushing 70 and I don't know how much longer they have. Both of my grandparents on both sides were passed away by the time they were in their mid-70s to 80. I don't know how much longer I have with my parents, and my siblings don't really talk to me. The only one I have is my mom. And with how expensive basic hygiene care is in here, $30 a month only lasts me 2 weeks in hygiene because how expensive it is. I have to severely ration my stuff to make it month to month. I'm simply asking for what leniency the court is willing to give me to please do so. I understand I made a mistake and misunderstood things as they were through my interpretation. I'm quite known for that, being a developmentally disabled autism patient. I misinterpret large amounts of information consistently. I've been dealing with mental health and behavioral health issues since I was 6. Whatever leniency the court is willing to show me, I'd be eternally grateful.
All right. Thank you, Mr. Newman. Oh, we've already talked a little bit previously in this case, as we have today, about this somewhat unique circumstance, and that they weren't images of actual children. They were anime images, which still feeds that same kind of desire, still feeds it, helps it continue. And yeah, I do understand there was a time, I think, where the statute as it was written, may not have made it a crime, but today I believe that it does. So again, I do somewhat appreciate that. And anybody listening to this or watching it could say, well, the judge is trying to condone it. No, I'm not, but I'm just saying here, whenever you're buying pictures or scanning pictures that actually are of children, that a child has been somehow abused somewhere, and those always impact the court in establishing a sentence here. I also recognize that you have been in jail, and the processing of this case has taken some time to get to the level where it's at. And while you do not get any legal credit for it. I am allowed to consider the fact that you've been in jail now for almost 5.5, 6 months. And I can give some credit when I go to issue the sentence. While it's not listed as credit, I may take it into consideration. At the same time, I look at the defendant's prior criminal history, and I can, of course, establish an appropriate sentence, give undue weight to things for which he's already been scored on the guidelines. However, I can take a look at some factors. The defendant's first criminal entry began as a juvenile, and he was on probation in that file for a little over a year before he picked up his first adult conviction. In that, which involved the breaking and entering with intent, he was given HYTA, Juvenile Training Act. He made it about 7 months before he had his first set of violations, and HYTA status was revoked, then followed by another probation violation, which caused the court to unsuccessfully discharge him from probation. After that, he made it about 2 years until he picked up another property crime. That one started off as a break-in and entering, but was reduced to a malicious destruction of property. In that, he was placed on probation in September and made it 2 months until November of 2012, where he picked up new criminal offenses. And again, they were property crimes. It started off as a unarmed robbery, but was reduced to a larceny from a person. In it, looks like he made it only a short period of time. Actually, I take that back, about a year before he gets into more trouble. Yeah, he ended up getting parole. He had multiple violations. Some of them were just months apart. In fact, he picked up entry 5 of 6 while on parole, and sure enough, it was another property crime. Looks like he got parole and was returned to prison for further criminal behavior. In fact, that's when entry 5 of 6 occurred in 2017. Again, he was on parole, and that was his first possession of child sexually abusive material. And it looked like one time he was given parole and made it about a week before being found with more CSAM. Then, in this case, while on parole. So we have a series of violations of probation, both juvenile probation, adult probation, and violations of adult parole. And
May I say something? May I say something in regards to the parole violation from my parole in 2024?
Yes, sir. Go ahead.
The parole violation was 43-day detainer, and I was found not guilty on that violation and had my parole reinstated.
Hold on, let me take a look at that. Hold on. Was that in 20, you said 2024?
Yes, I was released the Friday before Christmas.
Yeah,
The
I see that.
acting magistrate and prosecutor in my parole violation hearing found me not guilty due to none of the evidence being of an incriminating nature.
Okay, and I will note that that was on December 18th of 2024, but you violated on only a few months later on April 23rd of 2025, which of course is what resulted in these current charges. So I appreciate that, and I'll note that. I'll note that in that correction. But again, there's still violations while on parole. All right, so the court has to establish a sentence here that it finds to be reasonable and proportionate. And again, I take into consideration that he's been sitting in jail on a parole violation and doesn't earn credit for that. I'm going to keep my sentence within the guidelines. Again, I acknowledge also that the defendant accepted responsibility here. And the court finds, based upon the probation violations, parole violations, and continued conduct, that sentence is fair, reasonable, proportionate. First, the court sets a $68 state minimum as required by law, a $130 crime victims' right fund fee as required by law. I will refrain from any other fines or costs, and then ask for a period of confinement. Court sentences the defendant to 13 to 48 months. And of course, he's not entitled to any what I would call legal pretrial credit, but the court has taken into consideration that he's not earning credit. This also, and I consider this also for establishing the sentence, this must run by law consecutive to any parole violation sentence. Mr. Stapleton, have I missed anything today?
I don't believe so, Your Honor. Thank you.
Mr. Carnt
No, you are. Thank you.
and Mr. Harrison?
The only open question was our request to waive the collection of fines and costs.
But I'm not gonna waive the collection of the, because there's no fines. There's just the two state charges, right? So I took his request in consideration, and
Yeah,
I would have had another $1,100 on the guideline. Instead of all that, he has $198. That was my. All right, Mr. Newman, you will receive there at the prison 2 copies of one document. This document is entitled Notice of Right to Appellate Review. You have the right to appeal the conviction and sentence in this case. Based upon the plea, any appeal must be done by filing an application for leave to appeal, and not the claim of appeal by right, which is only entitled or required when there has been a conviction after a trial. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you must complete the bottom half of that document where it says request for appointment of an attorney and submit it back to the court within 42 days. You understand, sir?
Thank you, Your Honor.
All right. Again, I find this sentence to be fair, reasonable, proportionate. I find that it is within the guidelines, and I've taken into consideration the defendant's prior criminal history, but also his performance on bond and parole. And I've taken a look at the nature of the facts in this case. Thank you. All right, we're adjourned.
thank you.